I want to clarify here something. I've got a public defender over here, and Mr. Apiaji, who's not present in the courtroom, had told me that you wish to represent yourself today. I want to hear it from you.
Yes, ma'am. I'm aware of the I believe it's the Arguello advisement and all that, and yeah, I definitely feel more comfortable having my right to be heard reserved rather than let somebody speak for me on this matter.
Okay, well, I want to make sure that you understand you're wearing stripes, so you are entitled to have that public defender.
Yeah, no, I think I'd rather pass. No disrespect or nothing. I just feel like from our talk that like she's not really aware of like the whole statutes and things like that involved in what I'd like to say or represent.
Well, I tell you what, she's in my courtroom every single day.
I'm not saying, like I said, no disrespect.
No, I know. I just,
you know what I mean? When it comes down to some things like that, I just freshly researched and what she was saying just ain't matching up. You know what? I'll take the chance.
Okay, well, that's your right. Now, Mr. Mann, have you talked with Mr. Duncan? Because if you're going to represent yourself, Mr. Duncan is the prosecutor, and depending on the circumstances, might want to convey with you some type of an offer in the case.
I would love to speak with him if he's willing.
Mr. Duncan?
A couple of issues, Judge. First of all, the people aren't very compliant today to extend an offer, but we're obviously working on that. The second thing is that Mr. Mann on 2 felony matters, in one of them he has advisory counsel appointed, and in another one he has ADC appointed, and I'm not sure of the scope of that representation. So I'm just a little reluctant to potentially tread on his rights by, if anything comes up with those cases. So.
That's a maze to navigate, isn't it? So, Mr. Mann, let's pick apart what Mr. Duncan just said.
All right.
First of all, okay, I'm gonna go ahead and just advise you here. Did you receive a form? I want to make sure you, if you're representing yourself, that you have a form. Could Ms. Vigil, could we get a form for Mr. Mann?
So
this is your advisement of rights.
Okay.
And I want to make sure that you have one available.
Yeah, we can do that.
And that you have a chance to review that.
Did you want me to actually like fill this out and sign it and all that?
It's nothing that needs to be filled out and
Okay.
signed. I just want to give you a chance to review it, okay?
Yeah. Yeah, I'm aware of all these actually.
Well, take your time. I'm not rushing you.
Right. Basically today, you know, I understand that the state's not ready. They have had no contact with their main witness. They really probably don't even honestly need to.
Okay, well,
with
hold
the
on.
evidence that they have.
Make sure that you've read your form. That's the
Yeah,
first.
no, I understand all my rights when it comes to like, yeah, I'm aware of these. I mean, as you guys see, I've had a little bit, not
Okay,
proud,
this-
lengthy history.
Is my
I'm
job,
aware.
hold on, Mr. Mann, my job today
Okay,
is pretty basic.
all right.
And one of those things is to make sure you understand those rights.
All right, we'll take
So-
it slow. Sorry.
So my first question is going to be, did you review your rights? And I want you to be able to answer yes, so that my second question is meaningful, and that is, did you understand your rights? So just give it a second.
Yeah, if you want me just to read these real quick and.
Yes,
Yeah,
please.
okay, I got you. So this is the arraignment? Is that where we're at on this? This is today?
That's
Arraignment?
exactly right.
Right?
Mhm.
Yeah, so this is the day speedy trial starts?
No,
Target set?
no, the speedy trial starts when a plea is taken.
So after,
So
Yeah, okay,
when you
that's what I
go
thought.
before the court, speedy trial begins to run when the plea is taken.
yeah, I wish to reserve all rights and continue pro se if we can.
Before we dive into today's courtroom chaos, buckle up, because this is one of those cases where confidence meets complete misunderstanding of the law. We're following Jacob Mann, a defendant who genuinely believes court-ordered protection orders are more like polite suggestions than legally binding rules. And instead of listening to trained professionals, he fires his public defender after what he calls some fresh research. Now, if you've ever also attempts to modify a protection order meant to protect a domestic violence victim, all while referencing the wrong laws entirely. The judge stays patient, the prosecutor stays professional, and Jacob confidently walks himself straight into trouble. So keep an eye out for the moments where his legal logic completely collapses, the prosecutor dismantles his arguments piece by piece, and the judge
It's on the
Yeah,
floor.
yeah, I'm very well, yeah, I know these rights.
Any
I've seen them many
questions?
times.
Any questions regarding your rights?
Not at this moment.
Okay. So here you are facing several charges. The most serious charge is a Class 1 misdemeanor. The maximum penalties on a Class 1 misdemeanor are up to 1 year in jail, a fine of $1,000, or both, or a lesser combination. You are not facing any mandatory sentences, however. Okay?
Yep.
You understand your rights, or
Absolutely.
understand the penalties that you're facing?
I understand the penalties, ma'am.
Okay.
I mean, Your Honor, sorry.
Anything you say is fine.
All right.
Okay. So in hearing Mr. Duncan today, the people have not yet gotten a hold of the victim, and that must happen first. So until they have talked with the victim about a plea, potential plea offer, they can't make a plea offer to you. So
Right.
Ms. Benninghoven will hear of any information before you do, and then the people will be ready to go. So
So,
for today's purposes, I'm going to send you to a trial division. Okay? This is the arraignment division. I'm going to send you to county court where you can get your case set for trial.
yeah, that's cool.
Okay?
Um,
Do you have, Mr. Duncan, are both these cases in district court, or is there a county court matter?
There's a 22 CR, which is up in Division E, and a 25 CR also up in Division E. So I think this can just go to Division 5, I think is the week.
I'm not
Oh.
trying to have all my cases in the same courtroom, no, you know what I'm saying?
Right, except this is a misdemeanor and your
Yeah,
other two
no, I
are
understand,
felonies. So
the jurisdiction type issue. So,
I'm going to go ahead and send you into the county court.
okay,
You
something I'd really like to address today if I
Okay,
can,
hold
whenever
on, I
you
need
got
to
a
give you a
second.
date.
Yeah.
One thing at a time. Let's give you a date first.
November 5th at 8:45 in Division 5.
Thank you.
Okay, so November 5 at 8:45 in Division 5. Your judge will be Judge Nowak,
Which court
N-O-W.
number is that?
That's courtroom 303.
303, all right, cool. Thank you, Your Honor.
Okay?
Yeah.
So we've gotten you your county court judge.
So this is basically just being set over, this hearing?
This is being, that's exactly right. This
Alright,
is what
so-
we call our first appearance center, and then cases are routed from here. Now, you said you had a question. I'm
Well, you
not
know,
sure that I can,
I think it's kind of good that he hasn't spoke to the victim yet because, you know, I'm asking for basically a modification or a dismissal of the order, basically, and I have it all in writing here. I'm gonna have to need to amend it, but I know that there's like a 10-day deal on,
And right here is where things already start heading downhill fast. Jacob hasn't even gotten through the opening moments of court, and he's decided the public defender, who's literally in this courtroom every single day, doesn't know the law well enough for him. Instead, he trusts his own, fresh research. Now, this is a classic move we see in so many courtroom breakdowns. Defendants convince themselves that reading a few statutes online suddenly makes them legal experts, while ignoring the reality that law is complex, technical, and full of procedures that can make or break a case. What makes this especially risky is that Jacob is currently in custody. Those stripes the judge mentions mean jail clothing. This isn't some casual traffic ticket, this involves domestic violence allegations and protection orders. By firing his attorney, he's giving up professional guidance in a situation where
part of my rights as the defendant in the case, and that's on the protection order you guys gave me. So, if I have the paper here, hold on one second. It appears that I lost one somewhere, hold on. It's actually, I mean, you guys got it on file on the record. I mean, you really don't need me to give you a copy of it twice, I don't think. So, it's right here on the protection order you guys gave me, page 3 of 3 on JDF 440. If you look at the first part, it says you may apply at any time for the modification or dismissal of this order. So then here's you go. If you want to take that, please.
Mr. Duncan, if you could gather whatever the defendant is
I mean, I don't know. It
having.
says it right here in the order that you guys gave me. So I just,
All right,
I'm not
Mr.
trying to be
McKee,
rude.
I've heard you, Mr. Mann. Let's go ahead and let Mr. Duncan take a look, and then I'll take a look. Okay,
I mean, if you guys want to copy the order, I can give you it too. No, you don't need that? Okay. Sorry. If I could just have a copy, y'all can take that with you. Just call this one done. Go ahead and take this. Thank you. It's rights. I will probably make an amendment to that at some point due to the basically lack of law library.
It looks like, first of all, we're not very ready to address the protection order, so Mr. Mann can obviously make his motion, and then the
That maze to navigate line from the prosecutor is actually a huge understatement. Jacob currently has multiple cases moving through different courts, with different types of legal representation assigned, advisory counsel in one, ADC in another. That alone makes things complicated even for experienced attorneys, but for someone representing themselves, that's a legal minefield. Each court has different jurisdictions, procedures, and timelines. Mixing them up can cause delays, missed rights, or even accidental self-incrimination. The prosecutor is being careful here because he doesn't want to violate Jacob's rights by discussing matters tied to his other cases. Meanwhile, Jacob seems completely unfazed, as if all this legal complexity is no big deal. And that overconfidence
would be the court would need to maintain the VRA right of the victim to
all right.
be consulted on that.
Mr. Duncan, if you could actually hand that up to me, I'm going to have my clerk make copies.
Thank you very much. Because that's actually
Ooh, this is really faint.
yeah, I know it is. That's just what they gave me to use at the jail. You know, resources are very limited there. The law library is from 2010. It's not really updated. However, within that section that he mentioned, they actually reference 18-1-1001, which is the criminal protection order. So you might want to brush up on your laws there, Mr.
Well,
Duncan.
that's not nice, Mr. Mann. At this
Well, I know
time,
he's just trying to reject it because he doesn't want to address it, and that's
Mr. Mann, we don't talk like that in the
I
courtroom.
apologize. You're right. That was very unprofessional of me. It won't
it
happen
is.
again. I'm sorry.
So
I apologize to
for our
everybody.
victim rights amendment, it's
Sorry, I don't want that.
both a constitutional right and it's codified in our statute. And
Basically just
specifically,
requesting-
please,
Sorry,
I need you to be quiet now. It's my
Yeah, I will.
turn.
I'm sorry. I'm done.
Under 4.1, 302.5, this is a victim rights case, and the victim has the right to be notified before any modification of a protection order takes effect. So I will go ahead and take your motion today, but I'm
Thank you.
not going to address it today.
No, I wasn't asking for that. I just wanted to be, because, you know, I didn't think the victim would be notified by this point. And I was hoping that maybe basically all I'm asking for is the same protection with my name for her to like contact me, because she's been making attempts at the jail to like on the home wave thing, the community, you know, the telephone system there. She popped up on there. I deleted her. She came back. And like, there's been issues where like, you know, I've been also assaulted by her, and like, obviously
Here's another moment that shows just how disconnected Jacob is from the actual legal process. The judge is doing something very routine, making sure he understands his rights and the consequences of representing himself. This isn't just paperwork. Courts do this so defendants can't later claim they didn't know what they were giving up, but Jacob keeps interrupting, insisting he already knows everything, talking about his past history, and even trying to jump ahead to legal arguments before the court has formally moved forward. He's also confused about when speedy trial actually starts, which is a basic procedural rule. This matters because timing is huge in criminal cases. Missing deadlines or misunderstanding when rights kick in can seriously hurt you, and instead of slowing down and listening,
and it turned in no evidence of that yet, but like, except for like my testimony within this motion saying, hey, like I'm asking for the same protection that she's given, because it can't be a one-way street because of the fact that like this incident that's in question that is going to be litigated wasn't just a one-way matter. There was things back and forth done. I just told the police, look, I don't want her to go to jail because like, I don't feel like that, number one, she's not equipped to handle that. And obviously like, I don't want to bring damage on her. And number two, I wasn't at a point to where like, I'm able to furnish any evidence against her because of like the situation. I just wanted to make the court aware that, like, look, all I'm asking for is a modification to include me with the same protections that you guys are giving her, because there's been assaults both ways and damage of, like, you know, various forms. That's all I'm asking. So I know we
Right.
can't
And Mr.
address
Mann,
that.
that will be addressed at a future time.
Absolutely. That's all I'm asking.
We've got your motion on file. We're
Thank
done
you.
today.
Thank you.
Thank
Sorry.
you.
Sorry. And hey, I really didn't mean any disrespect to you, Mr. Duncan, or the court. I apologize. It won't happen
Well,
again.
but yeah, just be careful, Mr. Mann.
When the judge lays out the potential penalties here, this should be a reality check moment. A class on ice sound minor to some people, but up to a year in jail is no joke, especially when tied to domestic violence-related issues. And while there's no mandatory sentence, that doesn't mean the consequences is the point where most defendants would seriously reconsider representing themselves. Having a trained attorney could mean negotiating plea deals.
This is going to be an FTA, so I think the court maybe will want to call the other case at the same time. Mr. Mann, okay.
Do you want to pass it then and talk to him before we call it?
No, Your Honor, I still need to go to Denver, so I'm gonna ask for the court to set a new court date for Mr. Mann, and we'll still call it.
Okay. All right, so 22 CR 2848 and 25 CR 2733, Jacob Mann, entries of appearance. Well, just to be clear, Mr. Mann is here pro se, representing himself on 22 CR 2848, and then entries of appearance on the other cases. And I'm sorry, Mr. Duncan's here on that case also for the people.
And Nikki Nelson appearing as friend of the court on 25 CR 2733. Mr. Mann did bond out on that case early in October, was informed he needed to apply for the public defender's office, has not done so yet. So I'm going to ask for another court date for him. But if that application isn't turned in, I won't be appearing at it. So I just want that. He was advised by the court previously on 10/28.
Mr. Mann, are you intending on applying for?
Well, you know, Your Honor, I mean, I don't really know what's going on here, because they merged both these cases together on the same day.
But they're not merged together. Let me explain to you what's going on. And
Yeah.
it seems like you keep on having difficulties understanding some pretty clear
It's not
direction of the court. Hang on.
Sorry.
The cases, there's two cases now pending against you. One is set for trial. You have filed multiple motions on those matters. To be perfectly honest with you, there's zero record before the court in either one of the two cases that you're indigent. So I've already ruled on two of your motions, one of which was filed while you were in custody before you bonded out. That's in case number 22 CR 2848. That was where you were requesting an investigator. I've denied that motion because I have nothing before me that indicates, and I'm sorry, Ms. Jones, my apologies. Ms. Jones is here as advisory counsel on case number 22 CR 2848.
Thank you, Judge.
Thank you. I know I apologize for that, ma'am. I forgot there's got to get the advisory counsel in here too. So, sir, Ms. Jones doesn't represent you on that case, but she is advisory counsel. The reason I entered the orders is I have nothing before me indicating that you're indigent. At this point, you have not applied for the public defender in case number 25 CR 2733, and the public defender's office was representing you in that case while you were in custody. They're two separate cases. They just happen to be set on the same date, so we can address the matters on the same date, but we're addressing everything separately. The other issue the other motion that you filed that I didn't really deny, it's really there's just no action that was required, is that you file a motion to extend the motion filing deadline for 2 weeks. But you filed that when the motion filing deadline was, filing deadline was the 24th, which was the day before today, because today we were going to address kind of what was going on with motions at that point. I've not seen any, you have certainly filed some motions since that on case number 22 CR 2848. I've not addressed those motions at this point. The prosecution did file a response to your show cause motion, but nothing else has been addressed. I did rule on 2 of the motions because I felt like I had sufficient information to rule on those. And again, in one of them, really it was just you didn't need an extension. But having said that, no new motions have been filed. Last motions that were filed were on 10/20/2025. We're currently set for trial on case number 20.
Protecting rights or minimizing penalties. But Jacob seems completely unfazed, casually acknowledging the risks like it's just another route. Even more concerning is that he still seems convinced he's about to outsmart the system with legal technicalities. And as we're about to see, his biggest move, trying to modify the protection